I'm on a mission, and I have been writing articles for LinkedIn and lobbying the NACDL, and again trying to get information through Freedom of Information Act requests to inform defense attorneys around the country of this new policy and show them how to vigorously advocate for their clients' eligibility. And
Nice.
ultimately, I believe, as a result of Freedom of Information Act litigation, we will find out in each district what the particular policy is.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. It's a sunny Monday afternoon in Arizona. What's the weather like there in Florida? It's sunny, I'm sure, right?
Well, it's beautiful. It's sunny today, no humidity, and we are having a cold front, which
What is
means
it?
it's probably in the low 70s today and maybe in the 60s tonight.
Oh,
It's lovely.
perfect. Okay, well, for those of you who don't know, the golden voice on the end of this conversation is and is going to be a returning champion, attorney extraordinaire, gentleman named Jon May from Florida, Boca Raton. And welcome back, Jon. I'm going to tell everybody what we're going to be talking about in a second, but I just wanted to say hello after we had a lovely weather discussion. How are you?
I'm terrific. I just spent a week babysitting one of my grandkids, and it was just heaven.
I can only imagine. And if you ever want to come and just babysit my kids, for a week or two, you have an open invitation. I'm not sure you'll find it quite as heavenly as your grandkids, but who knows? They're pretty awesome in their own right. But anyway, for those of you who don't know, like I mentioned, Jon May is a lawyer. He's also a scholar, a writer, and a longtime criminal defense lawyer, and has lifelong career based out of the Miami area. The last time I had him on was actually a while ago. It was episode 38. So we talked about last time his new book, which isn't totally new anymore, but it's Who Says You Can't? How to Become a More Creative Criminal Defense Lawyer. And that was a great discussion. So I'm going to put the link in the show notes because we're not going to be talking too much about that. We're going to be zeroing in on a very specific topic today, because it's a big deal. And you did a little more writing on this, which is an article. I don't know if you have published it yet, but the article is called Non-Prosecution, Deferred Prosecution, and Pretrial Diversion Agreements. Just say no to please, which is another title that's near and dear to my heart. Is that article out yet? And if so, where is
Well,
it?
that article was published some time ago in the Champion. My book deals with the subject of different pretrial agreements
Oh,
intended
that's
to
right.
avoid a conviction and sentence. But more recently, because of newer developments, I've written some more pieces for LinkedIn addressing the new pretrial diversion program, which I think is going to be more impactful than the kind of other agreements that I had previously written about.
Okay, nice. Well, hopefully I can put some of those links in the show notes too. These things they're almost, I don't want to call them unicorns, these diversion agreements, but what they are is avoiding, being prosecuted in the best, avoiding a prison cell in the terrible, horrible, no good Bureau of Prisons, but also avoiding even a felony conviction, having your prosecution diverted, which is something that a lot of folks in the federal system don't. I don't know if they don't know about, or they just have a defeatist attitude and don't think they're ever going to get it. And so it just, I don't see a lot of people trying to get them. I don't see a lot of people asking for them. And I don't see a lot of people fully understanding, what is happening in the Department of Justice that might create a climate that makes it more conducive for us to make the ask and actually get the result. And so that is what I want to discuss with you today. And my hope is, dear listeners, you're going to listen to this and you're going to get scrappy and you're going to fight for a resolution that could help your client avoid the prosecution, avoid a prison sentence, avoid a felony conviction. So let's dig in. I want to first talk, because there's a lot of letters that are bandied about a DPA, a PTD, and all this stuff. So tell me about what we're really talking about is the variations on the theme of diversion, but there's a lot of different kind of buckets that these fall into. So you want to just give me the broad strokes of what the variations on the theme are in this for diversion?
Yes, but I have to give you a trip back into the 1970s. For years, there have been the practice of a kind of pretrial diversion. And it's really been an informal practice by various United States Attorney's offices across the country. Basically, offices since the 70s have had the authority to divert potential defendants into a program that will last a period of like 18 months or so, that is supervised by probation and gives the individual an opportunity to show they're really not that bad a person and that charges should not be brought. Originally, this was designed to address situations where you had someone really without any criminal background who committed a minor felony offense. Essentially, this avenue of avoiding a conviction fell out of favor. And what happened is that prosecutors either indicted someone for a federal offense, or they just didn't bring charges, or they deferred to state authorities. You always had situations that were the equivalent of what's known as an NPA, non-prosecution agreement, where you had an individual who may have been cooperating in some fashion, who the government just entered into an agreement that they wouldn't prosecute the individual so long as they continued doing whatever they were doing. Then you had, in I think it was 1972 or 1973, the creation of a more formal kind of diversion program known as Deferred Prosecution Agreements. Now, what was different with a Deferred Prosecution Agreement is that it involved the court. It was not a standalone statute or rule or provision. It was part of the Speedy Trial Act. And basically, prosecutor would go to a judge and say, I have an individual and he's going to plead, but over a period of time, he's going to, or she's going to demonstrate that they have rehabilitated themselves. And if they successfully act consistent with the requirements or the stipulations of this agreement, after a period of time, we're going to dismiss. So individuals, again, usually lower level offenders, had the opportunity to avoid a conviction if during a period of time they
Follow the rules.
Followed whatever rules, whatever stipulations, whatever the government wanted for this period of time. It was rarely used. But starting in the 1990s or the 2000s, it became a program that was made available to corporations, companies who had committed some kind of violation of federal law, mostly violations of Sarbanes-Oxley or the Foreign Corrupt Practices Act. And these were large corporations. And sometimes the government had an interest in making sure that these companies did not have a criminal record because they could be debarred from entering into government contracts. And sometimes these companies, if they were prosecuted, the effect of the prosecution could really impact on the shareholders. So
there's another theory behind that too, which I just learned from reading this book, The Chicken Shit Club. I don't know if you've read that book yet. But the theory is corporations are so well resourced and have such great, mighty, powerful armies of lawyers that the DOJ doesn't have the power to go after them, or they don't want to get embroiled in that kind of endless amount of resource drain and litigation. So they just they defer to the power of the corporation.
I think that particularly after the 2008 Great Recession was a significant reason why prosecutors around the country, particularly in the Southern District of New York, just didn't pursue cases that they otherwise should have because the resources arrayed against them were so great. So that's certainly a part of the reason. But the point is, a deferred prosecution agreement was never intended to benefit companies. It arose in the context of a system of diversion that was intended to benefit individuals. Now, so you had a pretrial diversion program, which was a pretty informal program, although it involved probation supervising very low-level offenders. That was used fairly extensively at one period of time and then became very rare. You had non-prosecution agreements, which have always been used and continue to be used, where you have somebody who the government really doesn't believe that they'll get a criminal conviction, but nevertheless still doesn't want to just say that they walked away without being investigated at all.
Yeah.
You had DPAs, deferred prosecution agreements, which started off as an avenue of relief for individuals. Then, in the last 20 or so years, involving prosecutions of companies, became almost the only remedy that the government used for prosecuting companies. And it was part of a carrots and sticks approach where they both gave the company an opportunity to demonstrate that they had reformed themselves under the threat that if they didn't, they could be prosecuted. But the reality was nobody or rarely were companies being prosecuted because they were offered this deferred prosecution agreement. Now, the one aspect of the deferred prosecution agreement that is still a pretty powerful one is that when you entered into such a conditional plea, at the state level would probably be referred to as a conditional plea, you had to sign a stipulation. And if at the end of the period of time the government wasn't satisfied and withdrew the offer of dismissal, the stipulation you entered into made it just about impossible to go to trial because you admitted everything.
Mm-hmm.
So there was some risk, but by and large, these companies had former assistant United States attorneys who had negotiated these agreements and made sure that the company satisfied whatever conditions had been imposed. When Merrick Garland became the Attorney General, he pledged to reduce the number of people who were incarcerated. And part of that was a new program that has been instituted by the Department of Justice called Pretrial Diversion Program. And this program at least has the potential to be used in situations involving defendants who are facing much more serious allegations and potential penalties. And what is really neat about this program is that it's not just pretrial diversion in terms of entering into an agreement at the beginning before somebody has been charged with an offense, or right after indictment in the case of a deferred prosecution agreement. This is a program that allows an individual to participate in some kind of activity prior to sentencing, which can be used to mitigate the sentence that the individual would otherwise receive. So pretrial diversion is something of a misnomer, and its potential is great because, again, it's not limited. In the Justice Manual, there are certain offenses that disqualify an individual from entry into a pretrial diversion program, like a sexual exploitation, or being the head of a large criminal enterprise, or a politician engaged in political corruption, that kind of thing. But by and large, pardon me?
National security, I think, is
Yes,
one. If
national
you have
security,
a couple felonies, I think. Let me ask you, because I want to make sure we're getting the terminology straight. My experience is more limited to the District of Arizona, and in there, we don't call them deferred prosecution. We don't call it pretrial diversion. It's more akin to what you were just alluding to. It's called a deferred sentencing agreement. So what happens is a person will plead guilty. They'll admit all the facts. Again, makes it real hard trial later on, and then the judge will set a sentencing date, however long you've agreed to defer. If it's 18 months or whatever, they'll set a sentencing date 18 months out. You'll be on pre-trial supervision, and you'll have those rules to follow, or those programs to complete, or whatever you've agreed to. And that if all goes well, that case either there's two ways they do it here. It either gets dismissed if all goes well and it's off your record, or they work out some kind of two-tiered plea where you're pleading to the more serious charge and then something really minor, a misdemeanor. And so if you succeed, the felony goes away and the misdemeanor goes on your record. I don't know if in your experience you're seeing that in other jurisdictions, because even though it's one federal system, every jurisdiction, as you know, has their own little peccadillos.
Well, in terms of this pretrial diversion program, it actually is sort of an amalgam of what was traditional pretrial diversion and the kind of program you're talking about. U.S. attorneys' offices around the country are in the process of formulating their own guidelines for the kind of pretrial diversion that is outlined in the Justice Manual, provision 9-27.010 and .100.
And that's a good practice pointer, just to put a fine point on that. So there was a DOJ memo, I think it was from December of 22, and that actually orders the districts to create their own policies. And you said they're in the process of doing that. I would hope they'd be done with it. They've had over a year, but the point is, you should ask if whatever district you're in. There's a directive now that they should have created a policy. So my first question in a case is, what's the policy? Do you have it? And if they haven't created a policy that in and of itself is kind of interesting, given that their boss told them to over a year ago.
Well, yes, that's a great question, and I've been trying to get the answer to that question. I have filed a FOIA, Freedom of Information Act request with the Executive Office of U.S. Attorneys, asking for every pretrial diversion program of
Nice.
every district in the country. I'm still
Oh,
waiting to
great.
get a response for that. I'm going to be filing a FOIA request in my own district, the Southern District of Florida, because the Southern District of Florida is not releasing its its standards.
Wow.
So it's a weird situation. People can apply if they heard about it. They can apply for pretrial diversion, but when they apply, they don't know if they are eligible, which makes absolutely no sense to me.
Well, me
What I
neither,
do
because
know,
ultimately the line prosecutor has a discretion that even if they qualify under their whatever policy they created, that doesn't mean they have to give it to them. So they could just as easily have said, yeah, I'm not doing that, and policy be damned, right? So why are they hiding the policy? That's weird.
well, it's also very inefficient because you'll have all of these people who are going to, apply, maybe make presentations. And let's say you've got a couple hundred US attorneys in an office. I don't know if it's 200 or 300 in the US Attorney's Office for the Southern District of Florida. I don't know what they do. They never try any cases. But then you have a review process, I presume,
Mhm.
among a very small number of people. So the office could be flooded with unnecessary applications or applications from people who don't qualify. Whereas if they had guidelines that were published, people would know whether or not to apply. And like you say, even if an office has guidelines that a particular assistant is supposed to follow, you'll never know if in this kind of district, you'll never know if you got a fair hearing or not, because if
Hmm.
the answer is no, how are you supposed to know? I believe that in some districts, and maybe most of them, there's a great deal of reluctance by prosecutors to use this program just because of the mentality of prosecutors wanting to ensure that people are punished for the crimes the government believes they've committed.
Right, right.
And
Everybody deserves a prison sentence, mostly in my
it
experience. In the
reflects,
federal system,
right,
that's their
it
position.
reflects a phenomena of institutions where the intent or the policies at the top of the institution don't come into effect or never effectuated because the people who carry them out essentially can ignore them or engage in all kinds of conduct that slows down the implementation of the policy, which is why U.S. attorneys' offices around the country have taken so much time, it appears, to promulgate these standards. I'm on a mission, and I have been writing articles for LinkedIn and lobbying the NACDL, and again trying to get information through Freedom of Information Act requests to inform defense attorneys around the country of this new policy and show them how to vigorously advocate for their clients' eligibility. And
Nice.
ultimately, I believe, as a result of Freedom of Information Act litigation, we will find out in each district what the particular policy is. And I'm going to make whatever efforts I can make in terms of my contact with the Attorney General's office to convince them that among some offices there's a rearguard action to defeat
Mhm.
the desires of
Yeah.
the Attorney General.
Well, and it's a lot. It's a bigger problem than just this issue, which is you have a national leader, Merrick Garland, who puts his wishes out there, and the line people in the various districts go, not really that concerned. Which is very. I have that scene from A Few Good Men playing in my head, where Colonel Jessup's on the stand, and and Tom Cruise goes, any chance you gave an order and they just said, the old man's crazy, ignore it, and he says, no, son, we follow orders or people die. But that doesn't seem to be the same culture in our federal system. And you know what I think the deal is? Well, first of all, I think that it's a deal about dehumanization, which is every single one of our clients are viewed by the other side as somehow subhuman and terrible people who deserve to have the hammer dropped on them. Otherwise, why am I going through this rigmarole of prosecuting them in the first place? I've done all this work. And then this whole notion of, don't make a federal case out of it. You've heard that. Don't make that's because everything is just a big fucking deal in federal court. Like if you're in federal court, it's a big deal. And why would we ever give diversion? Because everything's such a big deal. And then there's another problem in my experience, which is another systemic problem in federal and state court, which is luck of the draw, baby. There are some prosecutors out there who are completely on board with diversion, who actually have some heart and some humanity and will be more open and amenable to it. And you may get one of those, or you may get the rigid one who says, no way, no how, not on my watch, period, end of story. And it's just random. It's like the lottery. And that lottery effects is about the judge you get and the prosecutor and sometimes even the lawyers, the defense lawyers. But anyway, I digress. I love that you are on a mission, and I want to help you in that mission, which is exactly why we're doing this podcast today, to spread the word. So people need to understand this is an ongoing thing. As you start getting these FOIA requests back, maybe there's a list, maybe there'll be a resource. So keep checking back. And of course, Jon May's website and contact information will be in the show notes. You can always reach out directly to him. But what I would love to talk about now is, you said you're not only on a mission to make people aware, but you're on a mission to help them understand how to accomplish the goal. And I guess the first thing I'd like to talk about is what kinds of cases could we even have a hope to achieve this goal? And my hope is that you're going to tell me any kind of case, basically. But what do you think about? What do you think? Because you said earlier on, as this evolved, it was like only the most minor offenses in the federal system, which I'm not sure what that is, because everything's make a federal case.
Yeah, well, that's
tell me
these programs, or at least pretrial diversion, occurred within a very different context. It occurred in a context where certainly white collar defendants almost always got probation. Prior to
the guidelines.
Prior to the guidelines. Yeah. You also had a far different atmosphere before you had these mandatory minimums. And quite frankly, before you had drug organizations bringing in tons and tons of drugs into the United States and having wars in the streets. So the attitude towards crime and towards criminals became hardened, and that's why some of these programs fell into disuse.
That's a pretty salient point you just made. It's one more reason to hate the guidelines, because if you go to the guidelines, like you said, the majority of people get probation. Then the guidelines came out, and you look at the guidelines, and for almost every single offense you're going to come across in the federal system, the guidelines say prison. And so now they were butting up against that, and they say, well, if the guidelines say prison, why should I be giving you diversion? People don't know there was a history before the guidelines in the 80s, but there was.
And that's why I say the new pretrial diversion program is the most important development in federal criminal practice since Booker. But if you look back at Booker, it took years to get to the point where judges felt comfortable granting variances.
Yeah.
And the number of people and the percentage of people in different kinds of situations who are getting variances from the guidelines has steadily increased.
Yep.
But one of the things you said before is we work in a capricious system. Whether you're talking at the state or federal level, whether or not you can get the death penalty is going to depend upon whether you're black versus white, whether the victim, whether you have a situation of a black male killing a white female, whether you are prosecuted in the Southern District of Florida for possessing 10 kilograms of cocaine versus Billings, Montana, possessing 10 kilograms of cocaine. So
Yeah.
the kind of sentence you will get, despite the efforts to try to make sentences consistent around the country, will vary from prosecutor to prosecutor within a district
Yep.
and from district to district around the country. If you want to live in a fair system and avoid being severely punished, you want to not commit crimes. Because if you are arrested and prosecuted, you are subject to a system that may either give you a minor amount of punishment or a tremendous amount of punishment, and in any case, severely damage the rest of your life, because once you have a felony conviction, your prospects of ever earning a decent living, approach zero.
Yep.
And not to mention all of the havoc on your family of a long prison term.
Yep.
So,
Yep. It affects so
there's certain,
many facets of your life.
yeah,
So,
there's certain things about the system that are just horrible and unavoidable and capricious and arbitrary. And
yeah.
that's the system we labor in, and that's the system that we attempt to make as humane as possible for our clients, despite all of the institutional impediments to it.
All right. So I don't think we're going to expect for a diversion result in maybe like a murder case or a large scale drug trafficking case. Beyond that, like, do you say sky's the limit for what you can add? Like, what's a realistic expectation for the kinds of cases? I could tell you the last two that I have. I'll tell you what they were, but I just wanted to get a sense for what you think about what's realistic in terms of the charge to achieve the result.
Well, I was having a conversation with another lawyer who has had experience with PPP cases in New York State, and he was talking about the attitude of prosecutors towards these kinds of essentially a financial case against the government, where the government is a victim, in different parts of the country. Some prosecutors don't view it as a major crime, a significant crime. There's no violence here. The victim is the government. In a lot of circumstances, you don't have traditional criminals committing the crime. You had businessmen who were all suffering during the period of the pandemic and took advantage of a situation that presented itself to give them money that they needed, but only for certain circumstances that didn't apply to them, and they lied about it in order to be able to get the money. Now, you did have a large number of your traditional scammers and con men and criminals who defrauded the system, but you also had a lot of people who don't deserve a criminal conviction and who aren't truly criminals. Well, I think across the board, these people who fall into this category should all be eligible for pretrial diversion. Whether or not they're going to be eligible in a particular district is a question that is up in the air. I certainly believe that, whether we're talking about PPP fraud or healthcare fraud or telemarketing fraud or more serious kinds of cases such as the Foreign Corrupt Practices Act, in all likelihood, most U.S. attorneys' office are going to have some kind of dollar limit. It may be in some districts 200,000. It may be in other districts 1 million, but there will be a certain limit that psychologically prosecutors are just not going to be able to swallow if an individual actually steals a certain amount of money. That's my feeling. But in terms of the kind of case that we're talking about, I think virtually all fraud cases you're going to have an opportunity to seek pretrial diversion. Now, if you are involved in telemarketing fraud and your victims are all elderly people, you're not going to get much sympathy. And in fact, most of the offenders in those kinds of cases have been involved in. I mean, this is not a crime of opportunity. These are crimes where they're very much involved people who are very experienced and who you would find have been engaged in this kind of activity, for years.
Yeah.
That kind of fraud, you're not going to have too many instances where the government is going to consider pretrial diversion. Again, other kinds of frauds, even fairly serious corporate frauds, where the victim may be an employee stealing from the company, a lot of times these are crimes of opportunity where the employee has, never had any kind of criminal conduct in the past, may otherwise have been a good citizen. And, because this is a one-off, even if the amount of money is greater, that may be a situation. I think you might have minor participants in drug offenses where they will be eligible. Yeah. And depending on how large the organization, well, I don't even know if it depends on how large of an organization is, because it could be a large organization, but somebody who has a fairly minimal part in the organization, maybe an offloader on a boat, that kind of thing.
Yeah.
You'll have, even in drug cases, I think, the opportunity for pretrial diversion. Unfortunately, you're going to have people who, because of their socioeconomic situation, are going to be looked upon more favorably. I think physicians, lawyers, bankers, because they're going to have lawyers who are going to make really extensive presentations to prosecutors showing an individual has lived a very good law-abiding life and has all of these responsibilities to other people, whether it's employees or family members or sick kids.
Okay, so you just touched on probably one of the most important takeaways of this conversation, which is not new for the podcast and not new to either of us, but for some reason still a novel concept to some attorneys, which is mitigation starts at the very beginning. Mm-hmm. That you don't just say, all right, well, let's work out a plea and then we'll figure out mitigation. Because if you're going to convince a prosecutor, to give one of these deferred agreements, diversion, it's not necessarily just going to be about the facts of the case, or that they're a minor player, or maybe they were coerced in some reason. It's a big picture narrative about the human being who found themselves in this mess. And the more that you can communicate that to the decision makers as to why this human being is worthy of a second chance of diversion, the better off you're going to be. So don't wait to talk about what people affectionately refer to, or maybe not so affectionately, the soft stuff, the life story, because that is, I don't want to say sometimes, I don't know if I say more often than not, but that is what can win the case in a diversion situation. to be sure. You would agree with that,
Well,
right? I
I
mean, you were
have
just talking about that.
my philosophy of winning, even if you lose, and my agreement with you that this whole process, even if you know and intend and your client insists on going to trial, this process must begin at the initiation of your representation of the client. Because a lot of
Absolutely.
what you are uncovering during this time may keep your client from being detained and is necessary to develop over the period of time that you have before you would go to trial, and often involves gathering evidence that you could use at sentencing but would not be admissible at trial.
Yep.
So there are I mean, we're not just talking theory here, we're not just talking philosophy. There are very nuts and bolts actions, such as creating videos of your client and their family for presentation at sentencing, which I mentioned in the book as well, involving
Sweet.
some people who are well known for that, um, and that lawyers have to be doing, should be
Yes.
doing, and unfortunately, very few are.
It is so surprising how many times I get brought into a case for a video or something, and the plea is just about to happen or it's already happened, and you've got a month or two for sentencing. Just think of how much more we could accomplish. It's also interesting that what you talk about is getting these case dismissed or diverted because you've convinced the prosecutor they don't really have a good case, because ostensibly, I mean, it's in their manual too, they're not supposed to bring a case unless they think they can get convict beyond a reasonable doubt. But the point, I think the underlying point is, assuming they have a good faith belief when they initiate the case, is that they just don't know what they don't know about the case. Maybe they've taken the word of the case agent or the FBI agent. They've not necessarily sat down and met with these witnesses to determine if they're credible. They might not have read every piece of paper in the case. So, but there's in my experience, the times that I've been successful in getting diversion, it's kind of been a hybrid of, yeah, there's some problems with this case, and also this person really deserves a break. And I give you one example. Well, I could give you two examples because they're the last two that I got here, both in the District of Arizona, because I don't know. I think the culture here is better. I think there's more reasonable people here. Maybe it's because this is my home turf and I know, but I don't know. But one was a violent offense. It was an Indian reservation crime, when it was a pretty violent assault, and violent enough to be charged as an aggravated assault, which is felony under the Major Crimes Act. And there was a kind of a specious sexual assault allegation, which didn't make a lot of sense. So it wasn't even, that part wasn't even charged, but it was lingering out there. It was an alcohol motivated fight with a significant other, kind of mutual combat, but my client was severely intoxicated. And what it turns out is this young man never had a drink or a drug in his life until he came back from war in Iraq. He signed
Right.
up to the military right after 9/11 and was shipped out and saw the worst things imaginable, and came home and he was deeply traumatized, PTSD, and never got the right help and treatment, and he was kind of isolated on the reservation. There was a whole lot to the human side of the story, and the prosecutor gave diversion in that case, and that might have been the first one I can remember that was a violent allegation, but it was definitely a hybrid. And then the one I just got was an online threats thing, where a client was making threats to burn down the courthouse on Facebook or something like that. But there was great First Amendment arguments, and there was a lot of motions, pretrial motions, that were on the table that had yet to be determined, and a great human story. And the prosecutor, you know, reluctantly, but eventually gave diversion in that case too. And I think that bodes well for one other thing that I want to reinforce to the lawyers in our community, which is pretrial motions. Put that pressure on the prosecutor. File, if they're not frivolous motions, you've got good legal arguments, be it a motion to suppress, First Amendment, voluntariness, Miranda, whatever, because these are the things that kind of tend to sometimes make them say uncle and say go away, just go away. And we don't do that enough. And I just had an episode talking about guidelines changes, and people need to know they just fixed the third. It used to be the prosecutor could yank the third point for acceptance of responsibility if you filed a lot of pretrial motions and made them work too hard.
Right.
They can't do that anymore. And so lawyers should not be afraid, because even if you don't get the diversion, ultimately, it's not gonna hurt you in the way that it might have in the past. So hopefully that concept is not lost on our listeners too. What else? So
Well, there's another aspect I'd like to
yeah.
to just talk about in terms of the plea negotiations and trying to convince a prosecutor to allow your client to avoid a conviction. In chapter, I know I keep mentioning my book, but so
Oh,
much of
well,
it
I'm
deals with.
glad you did. And the link will be in the show notes for the book too, in case someone wants to go buy that book, because they
Right.
should.
One of the things that I do in chapter 11, deferred prosecution agreements, just say no to pleas, as well as chapter 6, confirmation bias in prosecutors, is that I believe that knowledge of psychology is very important in how you go about approaching prosecutors and judges too. But there are a number of phenomena that are helpful to know about, and I just want to mention a couple to you.
Please. Yeah.
Number one, the more your prosecutor knows about the human side of your client, and that of course goes into why your videos are so helpful. But the more time that a prosecutor can see your client and interact with your client, even if you don't have a proffer situation, the greater the likelihood that the prosecutor's attitude towards your client is going to soften. I mean, one of the things that you see is that when you have a defendant who becomes a cooperating witness and spends a great deal of time with agents and with prosecutors, when it comes time for them to be sentenced and for prosecutors to tell the judge that substantial assistance is warranted in the case, the attitude of the prosecutor towards the defendant not only makes a big impact on the judge, but reflects the fact that, and we all see this with our clients, the more time you spend with another human being, the greater the likelihood that you will develop some affinity towards them. And when agents and prosecutors spend more time with the clients, with not with clients, with their cooperating witnesses, they see them differently, and they may have seen them and they may have asserted in pleadings and in arguments to the judge how this particular offender is the worst person that ever walked the face of the earth. But that's not how they view them, and that's not how they talk to them by the time of
Yeah.
sentencing.
And
And
not to
that's another reason why I say that sometimes if you can't get a good deal, go to trial. Because one of the problems of sentencing is that usually a judge only knows the awful crime that the client committed, and sees the client for the first time at
yeah.
sentencing.
Yeah. It's a
And
crazy
so,
aspect of our system.
yeah, so whether it's understanding confirmation bias that affects our ability to convince prosecutors that a different set of facts are really true as opposed to the facts that they're relying on. There are all kinds of
Yeah.
things that you should know about in the way of psychology that help you to convince a prosecutor to look more favorably on your
Yeah.
client.
Well, and I don't want to make this about me, but you mentioned the sentencing videos, and that's my whole wrap on that is this idea that the judge, first time the judge lays eyes on you. And I said, I always say, ideally, in this system, we would invite the judge home into your living room and have her spend the afternoon with you, hearing your story and sitting with you and connecting with you on a human level. That's never going to happen. And my pitch for the video advocacy is that is the next best thing to
Well,
bring the
you see,
judge into your world.
that's why I've been such an advocate of you and what you do, because judges rarely allot much time to the presentation of favorable evidence at sentencing. And they rely heavily on the awful facts that are presented in the pre-sentence report,
Yeah.
the awful presentation that's in the government sentencing memo. So the only thing they really know is what you present in your sentencing memo, and maybe some evidence or testimony that you present at sentencing. Whereas when they get that disc or that file from you, Doug, with the video that shows the life of your client, it's in circumstances where the judge is either viewing the file at home or in their chambers, and they're not under any other kind of time pressure, and they can listen to it as many times as they want. They can reverse or go forward. It's a real opportunity to see the client as a human being.
Well, I so appreciate those kind words. And like I said, I didn't want to make this about me, but hey, why not? And if anybody wants to see some samples of those videos, go to my website, dougpassonlaw.com. But this is really about Jon May. So I think we might have come to the end of our amazing conversation, but I want to encourage people to seek out Jon May. And here's his website.
Website is Jon May Criminal Defense.com. And my firm name is now Creative Criminal Defense Consultants.
And I probably screwed up the name of your book, but I think the right version is Who Says You Can't? Strategy and Tactics for Becoming a More Creative Criminal Defense Lawyer, right? All
Yes,
right. And
available
so
from the NACDL.
available from the NACDL, and I will most certainly put a link straight to the NACDL so you can grab that book. What else do our listeners need to know about what's next for you, where to find you, what to do, anything? Did we cover it?
I have a Substack now.
That's right. The
I have a
Substack.
Substack that I write articles. The article that I published in the fall in Criminal Justice Magazine, that's an ABA publication, called an ethos for the criminal defense lawyer. That's been chosen as it's been selected as one of the top articles published
Nice.
in ABA publications last year. I've
Congratulations.
discussed pretrial diversion in my Substack with an article called Revolutionary Change and How We Will Practice Federal Criminal Defense. I'm also writing in a national public news publication called The Messenger about other kinds of topics, such as my article from January 23rd was South Africa argued the wrong case against Israel in The Hague, and that got 200,000 views.
Wow.
My longer
That's
articles
amazing.
are being published in another online publication called The Verdict. And I've been writing about the disqualification issue with Donald Trump and the argument in front of the Supreme Court. So that's the kind of stuff that I've been doing lately.
Well, it sounds like there's a lot that I need to have you back to discuss. So let's put a pin in it and just know that If anybody wants to go and find you and find all that stuff, it won't be hard. I'll put all the links, at least to the website and the book, in the show notes. So stay tuned. I just want to say thank you for doing this again. And I absolutely positively want to keep the conversation going soon.
Well, it's a lot of fun.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.